Taking the agenda forward now for the special address, we are delighted to have amongst us Shardul Shroff, Executive Chairman, Shardul Amarchand Mangaldas and Corporation. Mr. Shardul Shroff is the Executive Chairman of the firm with over 36 years of extensive experience in the general corporate, bankruptcy, insolvency, mergers and acquisition, capital markets, disinvestments, amongst others. Mr. Shroff is a leading authority on corporate governance, policy and regulatory practices, media law, technology law, amongst others. He's widely regarded as a pioneer in the field of corporate law, and he has been on a number of high-powered committees appointed by the Government of India and the states. Mr. Shroff has been consistently remarked as a leading lawyer by several international fora and publications. He was also a member of the high-powered Viradi committee constituted by the Government of India for examining issues of corporate insolvency and is a recipient of the National Law Day Award from the President of India. So on that note, warm welcome, greetings to Mr. Shardul Shroff, Executive Chairman, Shardul Amarchand Mangaldas and Corporation. Sir, we are delighted to have you amongst us, and we request you for the special address. Mr. Shroff, please.
Thank you, Dr. Amma. Honorable Chairman of the IBBI, Mr. T.K. Vishwanathan, speakers at today's summit, sponsors and esteemed guests, ladies and gentlemen. It is indeed a privilege to speak at this August summit, the 7th summit, as has been mentioned in the opening speeches. I intend to address some of the concerns that need urgent attention and help to improve the legal process around the IBC. A lot of valuable suggestions have been made by Mr. Vishwanathan and Mr. Ravi Mittal, and mine should be seen as an addition to what they have already propounded. There were 4 fundamental concerns when the IBC was conceptualized. And Mr. Mittal has already mentioned one of them in great detail, that the enterprise value reduces exponentially with time as the prolonged uncertainty about its ownership and control and general apprehension surrounding insolvency may make the possibility of resolution remote. The code therefore mandates closure of resolution process in a time-bound manner to preserve the value of the corporate debtor. It would not be out of place for me to mention the preamble itself, where this legislative direction has been given, because besides the Act being a consolidation and amendment statute, the preamble says that the reorganization and insolvency resolution has to be done in a time-bound manner for maximization of value of assets of such persons. Then it speaks of promoting of entrepreneurship, availability of credit in the interest of all the stakeholders. Now, this is a most important aspect which seems to be forgotten, including alteration in the order of priority of payment of government dues. Recent judgments have overlooked this aspect, and I'll point that out in due course. The second concern was that the process has to be based or decided on commercial principles, and therefore the stakeholders and the adjudicating authority have to decide matters with expedition. And the reason for the code of for the committee of creditors for taking commercial decisions is essentially because the value of the asset has become negative, and in some sense the value of the asset is really continuing on creditors' money because the equity has really got eroded. This was the justification the then finance minister gave when he introduced the SARFAESI Act, that the equity has lost its right to control the asset once its value is eroded. This was a statement in Parliament. The third aspect is what Mr. Vishwanathan mentioned, that when the firm fails to service the debt, the control of the firm has to shift, and the creditors must be put in charge to resolving the insolvency. That is the rationale why the code moved from debtor in possession to creditor in possession and creditor in control. Again, the experience which was seen in the context of SARFAESI and the SICA was that the process takes too long, and that the debtor remaining in possession creates a major risk of the assets in his control being frittered away, lost, or diverted. So there is a good justification for the creditor in control model. The earlier regimes allowed creditors to work out resolution or settlement with existing promoters. The code now enables them to bring any resolution applicant for insolvency resolution. Further, it prohibits anyone, including the promoters, who suffers from any specified disability from submitting a resolution plan. There is, as I mentioned, a credible threat if a firm undergoes CIRP that the control and management of the firm may move away from existing promoters and managers, most probably forever. So the rationale again into the IBC and the discipline that has been brought about in the IBC emanates from section 29A, which has both a moral justification and a behavioral issue involved. I'm glad that Mr. Mittal mentioned that out of 12 lakh crores, 6 lakh crores of debt has been resolved. This, I believe, is significantly due to the threat of section 29A, that the existing promoters who were sitting on their debt and not paying the creditors have now really realized the writing on the wall. There was a saying in relation to the SICA that there are only sick companies, no sick promoters. And that whole regime, this change in the regime in IBC has really drastically amended that perception that the promoters can enjoy and the company can go to the dogs. There are 4 innovative pillars of the IBC. Again, Mr. Vishwanathan has mentioned that. Besides the big data issue, I think the 4 basic constituents of the IBC are that it has created a class of regulated persons, the insolvency professionals, who play a key role for efficient working of insolvency, liquidation, and the bankruptcy process. It has created a new industry like that of the information utilities. Again, Mr. Vishwanathan has pointed out that even in the previous legislations, there was a need to have the security duly registered, the value of the debt clearly mentioned, and the priority of debts inter se also being clearly mentioned in the forms that were required to be filed. But the process has now been centralized, and an electronic database is created. This is to eliminate delays and disputes about the facts when default takes place. So the centralized theme that the information utilities certification of the value of the debt and its priority is deemed to be final or should be final is a step in the right direction. The previous issue of where does the jurisdiction of insolvency lie, namely which authority has the power according to value of the debt, that issue has also been resolved under the code because you have now an adjudicatory authority, namely the National Company Law Tribunal, and you have an appellate forum also. And in relation to personal insolvency, whenever that law comes into effect, the DRAT is empowered to deal with matters of personal insolvency. And finally, in a sense, the fact that there is a very active regulatory authority, namely the IBBI, which has oversight over the processes and the professionals under the code, gives the complete features of a robust IBC. I also wanted to point out here, there is a fifth element, which is really not under the IBC, but which is there pursuant to the Companies Act and the IBC when read together. The possibility of a continuing committee to review the law, to suggest amendments to the law, to act on the basis of terms of reference is permitted by the law. And you therefore have the Company Law Committee and the Insolvency Law Committee, which can aid both the regulator as also the Department of Company Affairs in quickly coming forth with changes and suggestions in the context of problems that arise in the law. And the example of the Vidarbha case and the example of the Rainbow Papers case are such examples where the ILC could definitely contribute to the suggestions for the way forward. I want to give a little different perspective also. Why was there an urgency in bringing in a reformed insolvency law? The origin of this issue finds itself of the source is the goal of doing business and the doing business project globally. If you will recollect, there was an ease of doing business index, which used to be created annually. And India was languishing almost at the end of the list of countries in the context of speed and ease of doing business. The rationale of that index, again, was to enable changes to the development of financial markets and the real economy. For this reason, there is a panel which reviews about 190 countries around the world for changes in the insolvency law. Three most promising trends in reform are essentially introduction of reorganization through the code. Several countries did not have the concept of schemes of arrangement, but we did, so in a sense we were advanced. Strengthening of creditor rights, because the parties which suffer the most when the money is really their money or the company continues to operate on the residual value of the company after the capital is eroded. And the third aspect is clearly protect the company's assets. These are regimes which are already part of our law, but it needs a further bit of tightening up so that we again improve. The concept of the review brought in two major issues, highlighted two major issues. That there's a concept of positive reform and there's a concept of negative reform. Positive reform is classified where there is a legal change which keeps improving the value in the corporate debt. For example, in a country, North Macedonia, it tightened the timelines and timeframes for insolvency proceedings and appeals, established electronic auctions of debts in assets, and implemented out-of-court settlements or restructuring. So some of the suggestions in this small country's example are capable of being emulated by us, especially issues of electronic auctions at the first instance, rather than upon a latter day failure to settle terms in relation to the resolution plan. A negative reform, on the other hand, is where more value is destroyed as the result of legal change, typically by making the insolvency process lengthier and changing the priority of the claimants. This is what has happened in the context of Rainbow Papers. And I will explain how this needs to be changed on an urgent basis. This is also what has happened in the Vidarbha Industries case, because as Mr. Mittal mentioned, the plan was to have the admission process completed in 14 days. Today, there is a complete uncertainty when a application under 7, 8, 9, 10 can be really brought to be heard and ordered. And with the introduction of a new variant now, that you have the right to argue the proposition that there are reasons, and this is not one case where insolvency admission should be the remedy, is a recipe for disaster, for the simple reason that everybody will raise that issue. And instead of having a simplified process of admission, you will have a long drawn argued position, which will create its further appeals right up to Supreme Court. So this kind of change, whether statutory or whether judicially brought in, is harmful to the process of insolvency. And we must be cautious and make these kind of changes if the judiciary really interposes its decisions or its interpretations quickly. I do recollect that the Ministry of Corporate Affairs and the IBBI very actively amended the consequences of a judgment of the Supreme Court and the NCLAT. It was not Supreme Court, it was NCLAT, in relation to the questions of sharing between secured creditors and unsecured creditors. The then chairperson of NCLAT had propounded a theory that it was up to him, notwithstanding Section 53 of the code, that he could decide the sharing principles, and that was a violent amendment, effectively, or a violent interpretation of the code. I distinctly remember that within 42 days, which is remarkable for a legislative change, the law was amended between the Department of Company Affairs and the IBBI. So they are known for their expeditious amendments, but they have to exercise the will to make such amendments, because that can only enhance the value of the IBC process. The issue, as I mentioned, surrounds or is framed in three basic principles. The reorganization, and the pre-placement is also one example of reorganization, or even the speed with which elements of restructuring can take place, and I'll amplify that shortly. The creditors being strengthened in relation to their rights, and protection of the company's assets, which also Mr. Mittal mentioned clearly, that avoidance transactions, tracing transactions, global cooperation, all these are features of protecting the company's assets. And perhaps this has been missed by us while thinking of introducing the model law. There are 2-3 issues which I will speak at the afternoon session, but I may mention it since Mr. Mittal is present and Mr. Vishwanathan, both pioneers in this process, are present, that the model code is now clearly not enough for India. It's a 25-year-old model law. The world has changed by covering group enterprises, which makes the law much more effective, because all corporates, including Indian corporates, don't merely set up branches. They set up subsidiaries, they set up joint ventures, they set up associate companies. And the money from the parent company has gone into such enterprises. Currently in India, we only have the ability to include in the liquidation asset the shares of the subsidiaries. But that is not enough, because the share value will continue to erode. The control over the share value is rarely exercised, because if the shares were valuable in terms of the liquidator's asset, then immediate meetings should be held in those subsidiary companies to seize control of those subsidiaries. Today, what is happening is that the promoter, who is a defaulter in the main company, continues to run those offshore subsidiaries or even Indian subsidiaries without really fear of losing those subsidiaries, except when there is a sale of assets. So this is, again, a premier issue which has come up in the context of adoption of the model code. And the second big issue, in my view, which we need to tackle, is this cooperation between countries who are part of either the model code or outside of the model code for cross-border forensics, for cross-border tracing of assets, misfeasance and malfeasance. Today, it is a law applicable in the Indian IBC, but whether that principle, there is no cooperation as I see in the model code for this concept, where very valuable issues come about. In the European context, in the USA context, they get a tracing order or a forensic order for the asking. In India, in the absence of an IBC law for cross-border issues of this nature, one will have to go to the civil court for permission of the Indian authorities to cooperate in relation to the cross-border issues of tracing of assets or common forensic investigation and common issues in relation to malfeasance and non-feasance. So these are the kind of changes which are positive and value accreting and must be made part of either the ordinary law, because this could apply even in the case of non-model countries, or when we come to the conclusion that the monies from India have been transferred by the promoters to an offshore destination, whether by over-invoicing, whether by round-tripping of funds. There are many ways today where the funds are getting lost to India, and there is no procedure in place for really doing offshore cooperation in the recovery of these monies. I understand that there's a deep focus on avoidance transactions and the forensic bit, because that is an underutilized element of the code. And there was a disastrous judgment of the Delhi High Court, which said that once the process of resolution is over, any pending inquiry is also over, which should never be the case, because resolution does not absolve the crimes against the company. The company continues to have a legal right for monies which have been taken away from the company. And this is a change, at least I believe, must be made, because you will otherwise have the overhang of that judgment being raised again and again. The aspect, let me focus now on the aspect of what's gone wrong on the Rainbow Papers case and why that needs to be urgently brought and amended. The Vidarbha Industries is a much simpler formulation, but the Rainbow Papers one has many more ramifications and many more political concerns which will be raised in the context of amending that position and restoring the IBC back to its original formulation. Mr. Vishwanathan clearly mentioned that the object was absolutely clear. And I think Mr. Mittal also mentioned that the object is revival. And revival in the expectation that a viable entity will emerge from the corporate debtor, which is capable of doing more economic activity, resulting in greater employment, greater taxation, and generally improving the Indian economy. One of the largest amounts of claims which really accrete to a company are the government dues or the government claims. Now, if one examines the definitions contained in the code, which essentially cover the definition of debt, cover the definition of a financial claim, cover the definition of financial creditor, cover the definition of an operational creditor. There is no doubt whatsoever that government claims were intended to be operational claims. And that is the only way in which Crown debt, which was otherwise first in priority with the secured creditors, pari passu with the secured creditors, came down to occupy the fifth or sixth position. That has been suddenly completely changed on the basis of an interpretation of may and shall, without looking at the issues of how these definitions emerged. The aspect which I want to focus upon is that when you look at financial debt, it is debt with interest, if any, which is disbursed. The critical word is disbursed. In a statutory due which arises out of sales tax, there is no disbursal. How can it then classify as a financial creditor and rank in the same element of financial security? Because there is no security also created. The word interest, security interest is also defined. And the security interest definition clearly says it is as a result of an act of financing, not as an act of a statutory claim. And there is therefore in the law clear understanding that there is no concept of a statutory debtor or statutory creditor. This is a conscious omission. The fact that the law did not create rights in the context of statutory debtors and creditors and left that position only for financial creditors and operational creditors and brought statutory creditors into the space of operational creditors is, in my view, conclusive of the fact that the question of security, the question of a statutory debtor being a secured creditor is not the law or ought not to be the law, because that's not the intention or the legislative purpose behind the IBC. Otherwise, the preamble, the discussions in the BLRC, the announcement by the finance minister that the government has brought itself down as an incentive to participate in the IBC, all will be rendered nugatory. So this is a fit case where either the ILC or the Ministry of Corporate Affairs or the IBBI, all of us together need to urgently bring an amendment so as to either and clarify that there is a mistaken impression in coming to this conclusion by judicial process. Unfortunately, even the review from Rainbow Papers and I think Vidarbha also, both have been dismissed. So there is a clear legislative process which must be used to bring about this change, because otherwise it is, as I mentioned, a negative reform, something which was valuable, something which was appreciated the world over as a positive aspect of the IBC has suddenly become a negative aspect. The priorities have been changed. In a sense, when government was intended to be an operational creditor, suddenly it now ranks with workmen and with the dues for the process of CIRP and the secured creditors out of the blue. People who have already invested in the country, invested in the process of IBC, lent finance in the context of IBC, are completely unsettled by this process and this judgment. It has already been pointed out in several meetings in the past that interim finance is critical for any corporate debtor to continue to function. It is not a case that all corporate debtors have sufficient cash flows and sufficient liquidity to sustain the enterprise as a going concern. If that be the assumption, then interim financing is a must. to delegate this function to the committee of creditors who have a perception that their security is in jeopardy, and therefore they should not let a new entrant come in, is antithetical to the policy of the law that the enterprise or the corporate debtor must continue as a going concern. The resolution professional has that duty to continue the concern as a going concern. If there is no finance in the system, then the resolution professional is not a magician that he can generate or create money and continue to sustain the enterprise as a going concern. And these are far-reaching implications even in the context of the liquidation regulations that are there. For example, the IBC and its regulations, I'm sorry, I shouldn't have said IBC, but the regulations of the IBBI contemplate that even a company ordered for liquidation can be sold as a going concern. The moment the company does not have funds, it stops to be a going concern, because trading or manufacture, any form of industrial activity, requires financing. So you can't really talk of transfer of a dead company, which has no going concern, to continue as a going concern in the hands of the recipient or the resolution applicant. So this has many, many consequences, and there is a time, I think now, to really look at this issue as to whether in the overall interest of both the resolution and in the insolvency, there is a need to equate the funding prior to the insolvency and subsequent thereto, because the gap or the hiatus that is brought about by not paying interest during the period of insolvency is completely putting off any interim creditor. They're not willing to take that risk. So this is an issue where clearly beyond the regulations, this cannot be rectified by regulation. This has to be brought about by change in the law. There is another issue which, again, I want to highlight, because the IBBI has very proactively introduced this concept of partial restructuring. Unfortunately, the definition of a resolution plan comes in their way, and a clever corporate debtors promoters will raise this issue to scuttle this partial sale. The reason behind this, and let me try and read out to you the definition of a resolution plan under section 526. It says it may include provisions of restructuring of the corporate debtor, including by ways of merger, amalgamation, and demerger. It means a plan proposed by a resolution applicant for insolvency resolution, and these words are not critical, of the corporate debtor as a going concern. What the IBBI has proactively done is it has enabled segregation of the enterprise into separate undertakings, each of which are capable of rehabilitation. As a result, partial remediation, partial employment protection, partial financial protection, partial change of the promoter are all now enabled by the IBBI through its regulations. But this section is contrary to what has been aimed by the IBBI. So my request and my suggestion is that this definition and this controlling provision that a plan can only relate to the whole enterprise and only if it's a going concern as a whole requires to be changed if the perspective of the IBBI needs to be given effect to, because otherwise somewhere down the line, and I hope never, this would be stalled. And the law is pretty clear that the act prevails over any regulation. In a doctrine of ultra vires, the delegated legislation will not prevail over the statute. So this is a case where we have an opportunity to change the law, since we're going to introduce the model cross-border insolvency law, to quickly step in and make these changes. I think I have spoken enough. There is always opportunity to speak more if you have been reflecting upon the code on a continuous basis. I pride myself of doing that and constantly thinking what more can the IBC do. But that's not today's opportunity. Today's opportunity is in the context of Mr. Vishwanathan's overview of the IBC, its purpose, functions, what it was intended to, and Mr. Mittal's perception of how the code has worked and how it can be improved. So I'll rest there. I will speak on the changes of the cross-border insolvency in the third session that we have, where I am a moderator, and we have some of the most excellent speakers, international experts also participating in the program. Thank you so much.
Thank you, sir. Thank you so much. Indeed, some very important insights you presented. And again, the very rational and pragmatic perspective of understanding IBC code as it is. Thank you so much, Dr. Thank you so much, Shardul Shroff, sir. Very interesting remarks coming from that very special address. Thank you, sir, again.